Ladies and gentlemen, welcome to the National Constitution Center. I am Jeffrey Rosen, the president of this wonderful institution, which, as those of you who have been here before know, is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. And this is the second of our superb winter town hall programs, and it's going to be a doozy. We are thrilled to welcome Amy Gajda and Ronnie Polaneczky to discuss Amy's superb new book, The First Amendment Bubble, How Privacy and Paparazzi Threaten a Free Press. Before I introduce them, I want to give a couple plugs for the incredible programs coming up. On February 10th, we have Zephyr Teachout, the law professor and political organizer, who will discuss her great new book on corruption in America. On February 12th, we're launching a really exciting initiative. It's Lincoln's birthday, and we are going to display a rare copy of the 13th Amendment signed by Abraham Lincoln to celebrate the 150th anniversary of the 13th Amendment. And that is going to launch 5 years of discussion and debate about the meaning of the post-Civil War amendments to the Constitution, the 13th, 14th, and 15th Amendments. And we will have Justice O'Connor, who's co-chairing a national advisory board to celebrate this anniversary, David Rubenstein, who's lent us the 13th Amendment, as well as a rare copy of Lincoln's Emancipation Proclamation, and the chair of the National Endowment for the Humanities. So it's and then a panel of incredible scholars to discuss the meaning of Reconstruction. But that's not all. On March 16th, we have James McPherson on why the Civil War still matters, and on February 13th, the opening of our great new exhibit of Camelot, beautiful pictures of Jackie and JFK interspersed with a discussion of their constitutional legacy and the importance of the civil rights movement. So that's all going to be great. I also want to share the exciting news that just today we're launching our National Coalition of Freedom Advisory Board, co-chaired by the heads of the Liberal American Constitution Society and the Conservative Federalist Society, the first time in history that these two groups have joined to co-sponsor a series of town hall debates across the country. We're going to have 6 this year about the constitutional issues of the day. And the roster of scholars on this board from all sides of the constitutional perspective is dazzling. These are the best scholars in America. And this is just a huge deal that these two great organizations from opposite sides of the spectrum have joined together with the National Constitution Center to transform constitutional debate in America. So it's so great to share that with you. Now let me introduce our superb guests, after reminding you, of course, to silence your cell phones and to write down your questions as they occur. Amy Gajda is an associate professor of law at Tulane University. The class of 2013 chose her as the winner of the Felix Frankfurter Award for Distinguished Teaching. She's an international expert in media law, torts, information privacy, and higher education. Privacy is my great passion and the thing I like best to write about and teach about, and I've so long admired Amy Gajda's work for its thoughtful balance. She describes how there are these two values in tension, privacy on the one hand and free expression on the other. They often clash quite dramatically. You have to choose among them, and striking the proper balance in a free society is one of the most challenging and important constitutional questions of our era. And she will discuss her great new book on the First Amendment Bubble. We are privileged to welcome back as a moderator Ronnie Polaneczky. She is, as all of you know, an award-winning columnist for the Philadelphia Daily News, where she's written since 1999. She's the most astute and widely read commentator in the city on every aspect of city life. She says, from the sublime to the stupid, but you can't read her columns without becoming more intelligent and learning something. So we're so lucky to have her. Ladies and gentlemen, please join me in welcoming Amy Gajda and Ronnie Polaneczky.
I'm going to have you speak with my my boss. I just think
and mine too.
Thank you so much, everybody, for coming. Amy is just going to be a terrific guest. She is a former journalist, and she is an attorney. So she knows both sides of how this issue of privacy plays out in the press, how the introduction of the internet and citizen journalism has affected this issue, also from a legal standpoint, how reaction to it could affect how the mainstream press, of which I'm a member, how we're able to do our work, find information and disseminate it to you. So thanks so much for being here. And
Thank you.
We'll just start right off. So this is her great book, and right up front, she says that she wrote this book because from the point of view of someone who knows how little journalism understands law, but also how little law understands journalism. So maybe you could just start off by telling us about that, Amy.
Sure. I think that journalists and journalism in general doesn't understand law in very sort of fundamental ways, like what a denial of cert means at the United States Supreme Court. So if the Supreme Court decides not to hear a case, what does that mean? And oftentimes I'll see journalists, not you of course, but describe it as a rejection by the court of some constitutional principle. And actually that's not right. But what I also mean is that I think journalism schools don't do a very good job at describing media law to their graduates. And in particular, the idea of privacy. So we get out of journalism school believing that we can report anything that's truthful about anyone, and we will be protected because it's true. So there's a real focus then on defamation and how not to defame someone. But there isn't a real focus on the privacy invading information that we can report. And I think that there should be. In terms of law, on the other side, I speak with fellow law professors and also lawyers, and they do not understand that mainstream journalism, as I like to call it, then abides by ethics codes. So if I speak with especially law professors, they believe that journalists literally will report anything about anyone that journalists find out about. So any sort of scandalous information, and that is their goal. Their goal is to get more readers, and so therefore anything scandalous is going to be instantly reported. And I can tell you that from speaking with law students, as I said, from speaking with my colleagues at other law schools across the country. So I think that there's that misinformation on both sides. And that's where I like to sort of think of myself as bridging the gap, having done work as a journalist, actually here in Pennsylvania, and then also having studied this in a legal sense as well.
Wow. Well, so you make a good point, and I'm thinking in my own profession, there are certain secrets that journalists keep every day. You may not think that, but there is when we say, does this really have news value? This person there's some private information we have about this person. Is this person a public figure to the extent that we could make a case for this? There's so much that we don't write about, but I don't think that readers understand that. But I do think that new journalists, say some citizen bloggers, other people who start their own websites, they think, well, it's all news, it's all true, and it's news, and it's going to go out there. So if you can describe for us a little bit the difference between citizen journalists and mainstream journalists, and where the clash comes up as far as privacy is concerned?
Sure. I think that what you said, of course, is true, and that's really shocking to a number of my law students, actually, that we would know information and not report it. And there are actually two camps. And the typical example is that there are a lot of politicians who have affairs, and we know about them as journalists, and we don't report it. And if you ask journalists whether or not they would report such information, many of them, I've asked at least, will say no unless it's newsworthy for some reason. So unless that particular politician, for example, is a family values person and speaking out of both sides of their mouth, hypocritical in some way. And that really shocks, again, a number of my law students. What's interesting today is that we have a number of publishers. I think you use the term new journalists. Yeah. I actually call them quasi-journalists in my book, because to me, many of them do not follow traditional ethics codes. And so their motivation is in getting the information out without any sort of thought. If it's true, they're going to publish it. And it's very different from the way mainstream journalism responds. And when I say mainstream journalism again, I mean reporters and journalists who follow traditional ethics codes. There's a ethics code that's the Society of Professional Journalists, and those are rules that many journalists live by. Many bloggers haven't been trained in such things. And so they believe, as do I think a number of people, perhaps in this audience, that as long as you report something true, you're going to be protected. And so therefore they have no qualms about reporting anything that's true. And so it's that clash that I think is also of particular interest as courts try to grapple with information that has never been reported in the past. Because our ethics codes, when I say our, I'm speaking as a journalist, not as a law professor, but
You
our
will always
ethics.
be one of us.
I know, thank you, thank you. Our ethics codes then will restrict that information. And so information is being published today in ways that courts are going to have to decide, is that information newsworthy? So newsworthy that in fact it deserves to be published despite the fact that it invades someone's privacy. And that is a tort. That's a tort called publication of private facts. It's something that has been a dying tort because courts could rely on journalists not to report that information.
Because they understood that we had this ethics code.
Exactly right. So it is said that journalists are the ones who get to decide what is newsworthy and what isn't, which may be shocking to you all. But if we then allow these quasi-journalists into that umbrella, protection in that sense for deciding what is newsworthy, we then lose our sense of privacy. We lose any ability to sue anyone for a privacy invasion because that individual has decided that the information that he or she has published is newsworthy.
So in other words, journalists were the ones who basically defined what was newsworthy.
And that was embraced by courts.
Right, and that was filtered through their own training in ethics. But once everyone's a journalist, then anything can become newsworthy. So therefore, nothing is a violation of privacy.
Exactly right.
Wow.
And that would include, for example, and courts are grappling with, again, this distinction now, but that would include, for example, I don't know how many of you are familiar with revenge porn, but that are images, photographic images generally taken by a young woman and sent to her love when the relationship breaks up. What sometimes happens is that the ex-love will then take those nude images and post them on the internet. Well, if anything that any publisher decides is newsworthy, we have to embrace even those sorts of images. And so that's what I'm trying to do. I'm trying to narrow this concept of newsworthiness to make it more in line with ethics codes that traditional journalists follow.
And you cite so many examples in one chapter, and I have to say, I have a teenage daughter, and I thought I knew everything in a certain area. I did not know everything. There is a website called Mugshots, or I don't know if it's still up. It's called mugshots.com. Mugshots are mugshots of people who have been charged with a crime, and so they're the kinds of things where, as journalists, we will call the police department and say, we need to get a photo of this gentleman. He's been arrested. We're going to write about him. So that is now considered, well, that's public information. So tell us about mugshots.com and what they do.
Sure, and there are a number of websites like this. So not necessarily mugshots.com, but they exist to get information from the government, like mugshots, and then create games, for example. Here's a lovely woman who was arrested, guess the charge. Or here is a person who's been arrested. We open this up for comments. What information do you think is relevant? How do you think she looks? What do you think his charge is? So the idea is using this information that used to be then newsworthy,
Right.
we would decide
Right.
then, which is again might be troubling for you all, but journalists decide then what is newsworthy, whether or not a particular mugshot, for example, or a particular arrest might be newsworthy. And because it's public information now, you have websites that exist solely, I think, to mock individuals who've been arrested. And you see a response from courts now, interestingly enough, where courts are embracing the idea of keeping the information private. So literally saying that even though mugshots are traditionally something that journalists get, deciding that in fact they are so private because it is an embarrassing time for the person who has been arrested, that they will uphold then a government decision to restrict access to those mugshots. In somewhat surprising cases, including the arrests of public figures, for example. So I think that it's a response again to this knee-jerk publish at all costs on the internet because the internet is free, restricting in a very obvious way something that we would traditionally believe is newsworthy, and that probably many of you would too. I mean, I see myself, for example, if someone has been arrested, I wonder what that person looks like, and so I will occasionally actually look for the mugshot to be attached to a particular story.
Right. And I think with the kind of websites that you're talking about, the way that I see them differing is that with mainstream media, we seek to inform. These other places seek to intentionally humiliate or cause emotional pain. And so that seems like a really clear difference to me.
Except that, I can give you an example, at least the last time I looked, the Chicago Tribune has on the very first page of its website something called Mugshots in the News or something like that. You can click on that and literally scroll through 100 images of people who've been arrested for very mundane crimes. And so even though it's pretty easy to, we think, to delineate between something that's newsworthy and something that isn't,
Right.
and condemn websites that exist solely to humiliate, there's an interesting line there between this decision by mainstream journalism to publish these images of people who've been arrested for what purpose? Maybe so that you click through them,
Yeah.
and 100 different eyes, 100 different views then may increase advertising dollars. And so even though, in other words, the delineation point is not precisely clear.
And I guess a question that raises for me is that because traditional mainstream journalism, I mean, our newspapers are struggling terribly in
Sure.
the city. Other newspapers have closed, and I'm wondering if the I'm sure I know that decisions are being made at a higher level, saying, okay, if clicks and views is the way to go, then I guess this is what we have to do. And so I'm wondering, it seems like you bring up 2 points. One is that the courts are sort of having a knee-jerk reaction to what really looks like an appalling abuse of public information. And they're reacting in a way that I'm thinking, well, that's justified. I'm glad about that. But then they could end up instituting new law that makes it harder for ethical journalists to do their jobs. And so a question I have for you, well, go ahead, you can respond
No, I was
to
just
that.
going to give you, I think,
Yeah.
a good example of
Perfect.
this, and I'd love to hear your responses to this if we have time afterward. But one of the classic cases I think that I am most interested in is, I don't know how many of you have seen the To Catch a Predator program on NBC. That program exists, and what happens in it is that there's someone who communicates via the internet with someone who is underage, and they try to set up some sort of sex meeting. The man generally shows up at a house to find a 13-year-old person there with whom he believes he's going to have sex, and it's actually NBC. And so NBC then outs the person as being a potential sex predator. I think that there's newsworthiness in that. I think it's important for people to understand that this stuff happens all the time, and it's shocking in that sense. Well, one of the men who had communicated with a 13-year-old was a prosecutor in Texas. And so he had communicated very graphically, and I've read the exchange between the 13-year-old and the man, very, very graphically, and he sent nude photos in every sense of that word, to the 13-year-old, but never showed up at the house. Police decided that, in fact, a crime had occurred, and so went to his house to arrest him. NBC followed to record the arrest, and sadly, he committed suicide inside the house. His sister then brought an intentional infliction of emotional distress claim against NBC. So arguing that NBC had intentionally inflicted emotional distress upon the prosecutor to the point that he committed suicide, and it used, in allowing the case to go forward, the court used these ethics codes against journalism, including the idea that we have to consider the ramifications of our reporting or some such thing. Now, no matter how you feel about To Catch a Predator and the way it reports what it reports, to me, that's a very troubling decision, because I can tell you that, and probably you would agree, I would think, almost every person who has something bad happen to them, when that information is reported, there is some emotional distress that occurs. And if what we are being judged on for a tort violation is these very ethereal ethics points, that is a very dangerous thing for all of media. And so that's, I think, a really wonderful example of a court deciding a case with a knee-jerk reaction that actually has the potential to change the way we report. So in other words, does that mean that when we find out that a public official is being arrested, we can't show up to cover the event? Because in fact, we may cause that person emotional distress? So the case ultimately settled. We'll never know what an appellate court would have decided. But that trial court opinion is out there and is something now that a number of plaintiffs' attorneys are looking to bring claims against media that they believe when media has not followed its own ethics rules.
Well, do they respond only when cases are as salacious as the kind of case that you just described? I mean, because, or are those always the cases that get the attention just because there's something so untoward about what he was alleged to have done and very salacious, whereas maybe if he were being accused of, I don't know, skimming profits off of something else, maybe we wouldn't have anybody at his front door. I don't know that we would or not, but I'm just saying.
Well, I think the problem there is that it's a very easy call. So I think any journalist and any court would say that's actually information that you all not only have a right to know, but that you need to know that information. It's when we decide not what you need to know, but that what you should know about your public officials and others. Maybe you don't have a need to know that well, I don't know, I think you do have a need to know, but maybe there are some of you who feel that you don't have a need to know about a prosecutor who has been alleged to have been soliciting sex from a 13-year-old. I think you do, but maybe you don't. Maybe you don't think that it needs to happen until he's been convicted or something like that. And that's sort of the unique line, I think, that and the privacy issue that is involved in a lot of these really close cases. You know, information that they may believe that is private to them, generally involving maybe their sex life, maybe something like that. And that's the more difficult question than sort of economic crimes.
You know, as you're describing these cases, it just, I think it reminds all of us that, the laws were written of their time. You know, when our gun rights laws were written, our founding fathers had no idea that one day children may have access to AK-47s. So the law has to be this living thing that continues to evolve. And I just think, with the privacy laws, no one imagined the internet. No one imagined the rapidity with which even false information could be spread. So is this part of almost a healthy evolution? Maybe I shouldn't use the word healthy. I mean, it's swinging. Maybe the internet is making it swing far more wildly than it would have in the past, but just because of how quickly we can really harm people if we chose to.
Right, and that's my concern. I think that when courts look to define newsworthiness and what is newsworthy, it was very doable in the 80s and even the early 90s when journalists were responsive to these ethics codes because readers wanted them to be responsive. Readers might, in fact, reject publications that cross the line, perhaps. But today, when we say that something is newsworthy, here's a great example, I think, that shocked me, and it sort of shows the other side, the other side of the coin, different from the case involving the prosecutor. There is a website out there called Gawker, and Gawker had got a sex tape featuring professional wrestler Hulk Hogan. And this was a sex tape that was surreptitiously recorded by his partner, alleged to be surreptitiously recorded by his partner. Gawker got this sex tape and published excerpts from it, very graphic excerpts. I watched the tape before it was taken down, so I can tell you that these were very graphic, full nudity excerpts from the tape. Hulk Hogan was shocked at this and filed a privacy lawsuit against Gawker, and one court found that he had a privacy claim, so much so that the tape should be taken down. But the last court that looked at it suggested, and this was this was a state appeals court in Florida, that state appellate court in Florida decided that Gawker had every right to decide what was newsworthy and what wasn't. And that if Gawker decided that this tape featuring nudity of Hulk Hogan was okay, then therefore it was okay. And so that sort of shows, I think, this new media quasi-journalism versus the more mainstream, and why I'm so worried about drawing a line someplace that gives journalists the ability to report on things that are difficult and privacy invading sometimes, but also recognize that we need to celebrate privacy, especially today with the internet, and that a line needs to be drawn someplace.
And I think that brings up a good point. Often when we talk about celebrities whose sex tapes have been shown or other salacious things, usually it's always around sex, if I'm not.
And I will say, though, that sex tapes are shown, but they're not shown on mainstream media. What I say is mainstream. So in other words, even if we do decide, again, collectively, if we do decide to publish a sex tape, generally what will happen is we will take an image of the tape, from the tape, and put black boxes where anything that would be too revealing would otherwise be revealed. And so traditionally you do not see mainstream media then publishing those sorts of things, although you're right, you do see other websites doing so.
So it seems like with Hulk Hogan, and I think with other celebrities, there's this sense that, well, if they're a public official, I mean, once you're a public official, you have no right to privacy. If this is true, we can publish it. And number one, we know that that is not true. But I also see that now is bleeding into lower level websites like these sex revenge sites where you may have a young girl who is engaged in a sex act. She's no Hulk Hogan. She's known to maybe 4 people. So there's even a blurring of lines between the erroneous thinking we have about public officials, and now it's bleeding down into people who are just normal everyday citizens, because we have citizen journalism.
Right. If they get to decide then what is newsworthy, if any publisher gets to decide what is newsworthy, privacy absolutely goes away. And can I talk just a little bit about the Communications Decency Act and its role in this?
Can she? Sure.
So there's
Please do.
So what is, I think, of particular interest to me, and what a lot of my law students are shocked to hear, is that there's something called the Communications Decency Act. And I don't know how many of you are familiar with this act. It was passed by Congress right when the internet was growing. And so Congress recognized that, in fact, the internet needed to be protected from lawsuits. Lawsuits generally, based on defamation, based on invasion of privacy, because it recognized the economic potential in the internet. It did not want to hold AOL.com responsible for every defamatory or privacy invading bit of information that was published on AOL.com. And that makes sense. So courts have looked at this law over the years and said, any Any internet service provider is not going to be responsible. And that has turned into any website is not going to be responsible. And so what has happened is that we have websites now that exist purposely to publish what we call revenge porn, nude photographs, generally of young women, sent to a boyfriend who becomes an ex-boyfriend, and that boyfriend then goes to that particular website and uploads the nude photos on that particular website. All, at least at this point, although there's some margin for some error here, which is interesting. I think courts are recognizing that this is an issue. The website exists exclusively for this purpose, and yet it's protected under the Communications Decency Act because of the way the Communications Decency Act is written and the way it has been interpreted over the years by courts in a way that is very protective of what is happening, of growing the internet. And maybe it's brilliant for these publishers to recognize this loophole, but I really wish that courts would get with the program, that Congress would get with the program, and recognize that line drawing is possible, and that we're not going to hold the Philadelphia Daily News responsible for something that one of its commenters writes, because that would be too much. But if there's a website that exists exclusively to invade privacy or to inflict emotional harm, that line drawing is pretty easy. At least for me, and courts draw lines all the time.
So if it happens coincidentally as opposed to intentionally, that's sort of the difference.
Right. If the website exists purposely for the point of publishing revenge porn, it should not be protected under the Communications Decency Act.
Does the mainstream media, are we enabling this because we are so afraid of any chipping away at the access to information that we need to do our jobs, that we are defending all the wrong people for the right reasons, but the wrong people?
I think so. I think it would be better to define journalists more narrowly, and a really concrete example of that is that the Communications Decency Act, and I think I'm getting this right because there's the Hulk Hogan case, and then there's the Communications Decency Act case. And the society, a number of journalist societies then filed amicus briefs in both of those cases, arguing that the Communications Decency Act should not be changed to be more protective of privacy, and also arguing that Gawker had the ability to publish whatever it wanted in the name of newsworthiness. So I think that that in that sense, it is wrong to embrace all publishers and to bring everyone under this journalistic umbrella, because if we do, then privacy goes away. And I would think that based on our codes of ethics, we recognize that privacy is a very important thing, and that it's something we should embrace. But the more journalists then side with these push the envelope publishers, the more those journalists could potentially be harmed by courts that are going to be knee-jerk responsive to those sorts of publishers.
That's a great point. Back in 1964, I just wanted to read this because the language is so noble. The United States Supreme Court said the First Amendment encouraged uninhibited, robust, and wide open public discussion so that in the end we would understand more about the world and come to know the truth, which just sounds so noble. And it's just so mortifying how that has been expanded to allow just intentionally harmful, non-newsworthy things to happen. And so the question is, so this is supposed to add to the public discourse. Is there something that you think journalists ought to proactively be doing right now to sort of stake our claim? Maybe that's what it is, because we actually do have the moral high road here, I believe, and the responsibility. So what would you have us do?
I would urge...
Or our societies maybe.
Sure. I would urge journalists to avoid this idea that all publishers are journalists. and I hear this all the time. I used to teach in a journalism school at the University of Illinois, and I heard it all the time that we need to, in order to make a vibrant First Amendment, there is no difference between journalists and any publisher. We are all journalists was the mantra. And the problem is, again, if we're all journalists, it is very privacy invasive, because anyone who publishes is a journalist. And so I think to avoid that, wonderful sounding notion that we are all journalists could be very, very helpful. The other thing that I would urge, if I lived in an ideal world where we didn't worry about the number of viewers, I would also urge mainstream newspapers to do away with these mugshots for the sake of mugshots. And the other thing that I would urge newspapers to do is to not open comment sections to every single story that is out there. So I am a journalist, and I recognize, as I'm sure you would, that if there's any sort of story out there that is salacious in any way, commenters are going to comment in really heinous fashion on those stories. If there's not been, if for example, a suspect has not been named, journalists will then not report the name, even though they know. They will not report the name. But I have, because this is my job, gone on to those comments and read that precise information, naming the person arrested, naming the victim. And I think that mainstream journalism recognizes that that's what commenters will do. And I'd sort of like them to take the high ground and not open those very obvious stories to comments, or at the very least take them down. And I think more are. And there's also newer is linking comments with Facebook. So forcing commenters to then reveal who they are, which actually then elevates discourse within those comments. So I think that those both of those things are a fine, something new that is great.
Sure, and I can tell you that that's a discussion that's happening certainly at our company, but with news organizations everywhere. And I wonder if the problem here is that when people, not wonder, I know this, when people can be anonymous, it can bring out the worst in them. Sure. And so if they were to be outed as someone who made a terrible comment, I think the power of public shame
right.
would be pretty potent.
And that's another idea that has just been so long standing in the law, is that we embrace anonymous speech. Yeah. Anonymous speech is important. It's what moved this country forward. It has been so important politically. And yet what's happened now because of the internet, and I don't want you to think that I'm opposed to the internet, because my goodness, I love the internet. Yeah. But what's happened now is that it's so easy to publish something anonymously that we are publishing very, very hurtful information and very, very private information about very young girls and women generally. And so anonymity in that sense is not something that we should embrace at all costs.
The comments sections, what is our legal exposure? Because I've heard different things, including,
sure.
Yeah, I've heard different things.
And that's a great question.
Yeah.
The reason why newspapers are able to have comment sections is because of the Communications Decency Act. So the Communications Decency Act is what allows newspapers not to be responsible for the comments that commenters leave. And so it is protected in that way, just like AOL.com is protected in that way. And so because it is these the newspapers and other media sites are just opening it up to public comments. We welcome your comments. They're protected under the Communications Decency Act, and so they can't be liable because of that law. That's how those things exist as well, without repercussions. And what is fascinating to me about it is that newspapers and magazines can be held liable for letters to the editor. And yet, at least very traditionally, when newspapers and magazines would literally publish letters to the editor, they can be responsible for the privacy and defamation information in those letters, but not under the internet, because not on the internet because of the Communications Decency Act.
So is that a loophole then? I mean,
well,
because how can we be held liable for
I think it's
Anything defamatory or
I think it's
privacy
not,
invasive.
I think it's not a loophole. I mean, I embrace those comments on news websites. I just wish people would, go through and maybe even vet them before they're posted. But maybe that's not possible in today's financial climate. So in other words, it's protective for a very good reason, and that is to encourage discourse. So we have this level of protection to encourage discourse on the internet. For me, I veer off in the other direction when there's a website that literally exists to flaunt pre-existing tort law, to invade privacy, to defame people, unlike traditional mainstream media news organizations.
So we have to be smarter about being journalists and saying, here's where the line in the sand is. We're not going there, you shouldn't, and you're not a journalist if you do. I think we've got the moral authority to do that, right?
Yeah, I think at least, yes, the moral authority is a very nice point. Yeah. And we need to define journalists in a way because there are a number of shield laws that protect journalists. And so if everyone is a journalist, trust me, courts are not going to buy that. And courts are not going to say, okay, Joe, because you posted something on Facebook, you're a journalist, you don't have to testify in court. They're not going to embrace that. And so all shield laws have the potential to go away if we're all journalists. And what shield laws are is that journalists who know information, who know of a source, may not be forced to reveal their source just because the prosecution wants them to. And it's mostly by statute, so it's mostly a law that suggests that, and so we need to define journalists at least in that way. I think we need to define newsworthiness as well, but for that very reason, we need to decide who is a journalist.
So you're saying if everyone's a journalist, then maybe none of us will have access to protection through the shield laws?
I think that's exactly right.
Wow. Which means a certain kind of journalism will really go away.
Right, yeah. and that's why it's so frustrating for me to hear the mantra that we are all journalists, because it really does, I think, bring everyone down to that level where basically we are all publishers.
Okay. Thank you. We have about 15 minutes left, so I thought Robin is collecting questions, so maybe
Great.
Questions from our audience now. So here we go. Put on my glasses. Okay. First thing I'm going to do is the one that is most important to you. I want to mention that there will be a book sale and signing of Amy's book in the museum store right after this program. Thank you, Robin. It would be a shame if she came all the way here from Louisiana.
Oh, I love. Are you kidding? I love chatting about this. Come chat with me afterward because I find it so interesting to get public perception about these issues. So my goal here is to chat with you all. I shouldn't say this for the publisher's sake, but not to sell the book. So I love chatting with you all.
Okay, here's the first question. Who should be the censor, C-E-N-S-O-R, or should there be no censor to protect individuals and the public?
Well, that's a really wonderful question. I struggle with that because so I worked as a lawyer for a number of years representing corporations generally. And we would always be very fearful about going in front of a jury because we knew that juries did not like us as corporations very much. If you speak with media attorneys have the same sort of fear. And so even though some people believe that juries should be the ones to decide these cases, my worry is that juries would most often decide in favor of the poor plaintiff as opposed to the media corporation, let's say. And so I actually want to push that decision onto the judges before it even gets to the jury, except in cases, and this is how I try to define what is newsworthy, except in cases involving human dignity. So except in some sort of case involving our traditional notions of human dignity, nudity, sex, those sorts of cases.
Medical
records medical
and
information,
things,
right, health information that we have traditionally protected. In those sorts of cases, I would urge, in fact, my idea is to say that there should be a presumption of newsworthiness for anything that is truthful. And that would then help protect, I think, against cases like, for example, the case involving the Texas prosecutor. That sort of thing, I think, is truthful information, and therefore there is a presumption that that is newsworthy, and it would be protected in that sense, most probably. In cases of human dignity, I think that it might shift into a jury decision and let a jury decide under those circumstances if, in fact, then the dignity of the individual trumped whatever sort of news value there might be in the information that was revealed. So I fear juries, but I fear juries because I represented those corporations, and I know that sometimes juries will in fact make the wrong decisions only because those corporations have a lot of money, as opposed to the poor plaintiff who's had their privacy, his or her privacy invaded.
Great question. Here's another really good question, I think, from Donna. She says this is regarding mainstream versus quasi-journalism. Are organizations like TMZ and blogs forcing journalists to change? And then two, much of the media reporting on major events seems to be supposition. Anything to fill the news day. How do you think this differs from the
Yeah,
past?
I think those are two separate questions. The first one is how is mainstream media becoming more responsive to what I like to call quasi-journalists? I think that it is. And so I think that, for example, in the Hulk Hogan situation, the New York Times did in fact publish something on its website as regarding the tape. It didn't show the tape, of course, but it did include some somewhat humorous and I think somewhat graphic quotes from people about the tape. And so I think that mainstream media has to be responsive in a way, because it wants viewers, it recognizes that these mugshot sites are going to be out there, and so therefore might be pushed toward that to try to get more money. So the answer is yes. I think they are in fact being responsive to the sorts of things that are reported by what I like to call quasi-journalists, but just not in the same way. And then the second, I was going
to say too, and the Hulk Hogan thing, there was the exposition of the tape, but then there was the hubbub around it, which then became news, which perhaps the Times felt that they needed to at least weigh in on.
Right, exactly, which I think that they do, and my point here is just that the choice of language was pretty salacious involving the Times, which was shocking for me that the Times would include this sort of more salacious detail, I guess, and plays on words, I guess I'll put it in that way. Yeah. Salacious plays on words.
Wink, wink, nudge, nudge.
Right.
Yeah, okay. And the second part of the question again said, much of the media reporting on major events seems to be supposition, anything to fill the news hole. How do you think this differs from the past?
And of course I would disagree with that.
Oh.
Of course I would disagree with it. So I think that most things that are published, and I'd love to have that person give me an example, but that most things that are published may in fact be designed to fill time. I think especially on news, cable, news-focused cable channels. But I still believe that whoever decides, the producer who decides that information is going to be published has literally made a news decision to publish that information. They have made the news decision to invite this person and this person to in fact debate that particular issue. And so to me, I can't remember the precise word that he or she used. So in other words,
Losing my question.
Yeah, it's not supposition.
Supposition,
Right,
thank
exactly,
you.
Supposition. I just don't think it's supposition because they also know, by the way, that they're going to be responsible if the information is wrong. And so they're going to be responsible in defamation. And so it really can't be supposition because they can be sued for defamation if in fact the information is wrong.
Okay. Here's another one. Discuss newsworthiness versus national security. And there's a second part to it, which is interesting. What audience is newsworthiness directed to? This is what we had asked, if there's different publics.
Right.
The readership, the general public, a segment of the general public?
Right. So in terms of newsworthiness, the Supreme Court has said language like this. I can't remember precisely what the language is, of course, right now. Of course, I wouldn't be able to, of course. But it suggests that things like troop movements might be protected. And so troop movements in that sense then, but it's a different sense of newsworthiness in the way I am describing it, which is in a tort sense. So not in a national security sense, but in a tort sense, meaning that if information is revealed about someone, whether or not that person should be able to bring a cause of action in privacy against anyone who has revealed it. So it's not so much a collective sense of what is appropriate and what isn't, but what is an individual, if an individual is at heart, what information as regarding that individual is newsworthy. With regard to the public, this is a really tough call. I think that the focus should not be on the public and what the public finds newsworthy. And the reason why I say this, and this is why I'm shifting away, because I'm not trusting those juries. Remember, I'm not trusting the juries, because 3 million people watch the Hulk Hogan sex tape. If 3 million people watch the Hulk Hogan sex tape, that is newsworthy.
But is that fact newsworthy as opposed to the tape itself?
No,
newsworthy?
it makes the tape newsworthy in the way we have traditionally defined what is newsworthy, because you, meaning the public, have decided that it's newsworthy. So my focus.
But if we wouldn't have known about it.
Yeah, the point is that it has to be a collective public. Okay. So the way I like to think about it, and this is pretty easy, and I haven't seen any courts do this yet, but we talk about this when we talk about this in my my classes, is that there is a beautiful way right now for news organizations to argue that something is newsworthy, and that is number of clicks. Mm-hmm. And I just don't think that that's appropriate, because the revenge porn websites get an awful lot of clicks. Sure. And so therefore, shift away from what the public thinks is newsworthy and really look at it in a legal sense, not worrying so much about, I think in a very traditional journalism sense, in the way an ethical journalist would in fact decide whether or not that information is newsworthy. Does that individual's privacy outweigh the public interest in the story? And so for me, I care more about the individual whose privacy has been invaded than I do about whether or not the public thinks something is newsworthy. Mm-hmm. Just because I have seen a lot of these stories and a lot of these revenge porn sites get instant clicks. Mm-hmm. Thousands of people clicking on revenge porn websites.
Okay, thank you for that question. Here's another one. PolitiFact recently judged the truthfulness of TV news, and the results were very negative. How can we trust mainstream journalism with showing judgment on privacy if they can't show judgment on telling the unbiased truth?
Well, I think I would question. That's why I like to think about mainstream journalism. And I would like to see that report, and I would like to have the ability to look through that report myself and to see how it was done, because oftentimes, of course, those reports have some sort of bias within them, and also they're oftentimes written by people who don't understand journalism, and who, especially, I have to say, as someone who worked in television for a number of years, especially television journalism, so especially video journalism. I would say that the reason why you can trust mainstream journalism is because, at least traditionally, and I'm not sure how often this is happening within news organizations today, we the reporters, have to vet our stories with others. So before information is published, we generally have at least vetted any sort of privacy invading story with our editors and with others in the newsroom and literally taken a vote as to what is appropriate and what isn't. And so therefore, it's not just an individual who is making the call. It's actually a newsroom making the call as to what is private and what isn't. And I think also traditionally, for the person who asked this question, traditionally again, we don't report the stuff that I know you want to know. And I know you want to know it because I talk with hundreds of people about this every year, and they want to know the stuff that I knew and didn't report. So we do hold stuff back all the time on privacy grounds. And so, but the point is that most people don't know this, and so whoever did this report wouldn't then be able to actually analyze this in any sort of way, because the information we know, we don't want to share with others because it is so, we believe, privacy intrusive to actually then be trumped by the news value within the information.
You know, it's interesting when you make that comment. One thing that has me worried as a mainstream journalist is that newsrooms everywhere have been decimated, and we've been decimated, so our ranks have been so thinned. I can speak with confidence about my own paper, but I also know that there are many papers where there's not an editor available to turn to, and so there's a little more is being done, maybe without some of the comfort that came from having many safety nets beneath you. And I worry about the future of our industry just because we're losing bodies. And that's where the checking and the double checking comes up. You know, as I had mentioned to you before, with some citizen journalist websites, I've seen people get news up immediately, and I know that it has not been checked. We may hold it for a while until we can actually check it, so that when ours goes up, we know that it's correct. Theirs may be correct coincidentally, and I'm just thinking the day's going to come when it is not. And we still cling to our right and the necessity for us to do that, but it's getting scary.
I think that's right. The only difference here is that generally, I think even people who report for mainstream news organizations recognize codes of ethics. They've been trained in defamation, so we know, even if we're reporting from the field and publishing instantly, which does happen sometimes, we have been trained in this, and so therefore, I'm less worried about that sort of instant publication. So I think, in other words, there's a difference in that sense. But that's why I'm so worried about courts' response, because what is going to happen is that right now, courts will oftentimes look and suggest, for example, that a number of steps were followed before information was published. And because these steps were followed in this way, then the publication cannot be liable for the information that was published. If we do away with those steps, I think that those courts that look to those steps as being as a reason for protecting the publisher will change their minds. And so that's my worry about what's going to happen with mainstream journalism. Because the more those courts change their minds, the more fearful mainstream journalism is going to become about reporting anything. And especially the stuff that is really difficult and perhaps defamatory, perhaps privacy invading. And especially if the mainstream news organization is under intense financial pressure anyway, why risk it? Why risk it? Don't report it until you can absolutely find, 10 people to go on record and say it's true. And that's the really scary thing to me, I think. That's what I think has the potential to even out mainstream media and what I like to call quasi-media, and leave us in the same spot because of that anger that I see from the courts. An appellate court, a federal appellate court judge warned about this in the 1990s, so even before the internet, and said, I feel bad saying this, and yet you watch, there is a backlash coming against the press in First Amendment jurisprudence. And that's what I think is literally happening today, even in truthful reporting of information.
Wow. And on that worrisome note, we will end our discussion. And thank you so much for being with us today.
Yeah, thank you all. Thanks for having me, and thank you for having me. It's an honor to be here.
And as a journalist, it makes me happy that we have someone like you looking out for us. So thank you.
Thank you.
It's a personal thank you. And don't forget to go downstairs, meet Dr. Gajda. Doctor or professor?
Professor, just have a
Professor
JD.
Gajda. Okay.
Not a PhD.
Professor Gajda. Okay. Thank you.